top 5 ways to negotiate debt in small claims court, part of the series Mediating with or Without Attorneys with Tye Bourdony. Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hi everyone, Mac Pierre-Louis here, attorney, mediator, and arbitrator working throughout Florida and Texas.
And Natalia advocate, mediator, and arbitrator based in Warsaw, Poland.
And I'm Tye Bourdony, professional mediator and primary mediation trainer in Orlando, Florida. And I have Ms. Michelle Da Silva, who is a 3L law student and is also interning at my law firm, the Mediation Center of Central Florida. And she's almost done with law school. Well done.
Yes, thank you.
Yes, welcome, Michelle. It's good to have you on today. And we both remember how it used to feel to be in law school. So congratulations on this upcoming achievement.
Thank you, sir. Appreciate it. And thank you for having me here.
And after greeting everybody and after realizing how lovely it is to be here again, I want to segue into the topic of today's podcast. We've been already touching on the mediation in the small claims court. However, today, since the topic is so important and really applies in so many situations, we want to deepen it in a way that will make any mediation you might be considering far easier and more productive for you. And this is how we came up with the topic of top 5 ways to negotiate that in small claims court. And we shall start with the first question to Tye. What do you think is the first thing that people should do, and why do you think that, referring to the topic of the entire series, the lawyer's involvement in a small claim should be in this very sense to make it more productive?
Right. And I would tell you that it's 1 and 2, right? They kind of go back to back. And the first one is, most folks just tend to, when you're sued on a debt, and that's primarily what we're talking about. Small claims can be anyone in a number of things, but in this case, what we're talking about is, a lot of those cases, they're being sued for debts. And so folks will just be very nervous and they show up. And what they didn't do was go get a consultation, right, from an attorney. So if you're not going to come with an attorney, maybe they don't have money. That's why you're kind of there. But you can go get a consultation at the very least because it can help you, right? And there are ways and places that you can get consultations, hopefully for free or for a very low amount of money. But hiring an attorney and consulting with an attorney are 2 different things. And one costs a lot less. And so why? Because when you get there, you have to know what your rights are. You have to know what the law is. You have to be able to, someone should have kind of walked you through it and given you some advice so that you have something to work with, because a lot of folks, they just have no idea what's going on. They're like deer in the headlights and they just don't do as well as they can. And so if you don't at the very least get legal advice, whether it be for some nonprofit or paying an attorney, you might also consider hiring an attorney, right, to let them take care of it for you. And the question that people really need to ask is, well, how much is it that I'm being sued for? And does it make sense for me to hire an attorney? What's that going to cost me? And what will I wind up saving, right? And then the other issue is, depending on the issue, depending on the debt, sometimes you don't even have to pay for the attorney, because if the attorney wins, they'll get the fees from the party who loses, from the party who's suing you. Seek legal consultation and or hire an attorney if you can. Do your research, be prepared.
So thank you for that. I understand that the 2 first points from our list of 5 top ways that you can be effective and productive in the mediation in small claims court would be consult an attorney, and the second, hire an attorney.
If possible. Yeah.
All right. So let
Not
me
always
say,
possible, but sorry.
it's completely okay. Let me segue to the third top way, and that is to be prepared to settle with some kind of number in mind, right? Nothing is worse than going to negotiations and just spitting out, well, I have an idea or I have a suggestion. You kind of need a plan. So I'd like for you to speak on that, but I also like Miss Yale to chime in as well with any examples that she might be able to give.
Yeah. Maybe we could start off with Miss Ciel's example.
Yes. Well, I'd like to share an experience of something that I observed during a mediation. It was a bank coming against a party who indebted herself for $5,000. So she was not represented, but she was a good negotiator. And I praise her for that because I thought she did great. So the bank, she owed $5,000. She was in arrears for 180 days, so she had not paid her card. The bank offered her $3,000 to settle the matter. She accepted with two contingencies: to make monthly installments in 3 months. And not only if that wasn't sufficient, she asked for the bank to remove the negative reports to the credit bureaus. I thought that was amazing. She did it all on her own. I'm not sure she did not make any representations as to if she consulted with anyone prior to the mediation, but she went in ready to negotiate. I thought that it was great. She did an awesome job because it served both. Both parties were willing and they settled, and I think it was great. It was great.
Thank you. Tye?
That's a good example. And it's really nice when you see parties who aren't represented, pro se parties, who are able to do that. They're not always able to do that. It is a shame. But the point is that it depends on the debt. But a lot of times this debt is from a third party debt purchaser. It's been purchased. And so they pay a lot of times pennies on the dollar. So the point is they're going to be willing to settle on that debt. And I would tell parties, if it's $5,000, I would start off at 25%. And I know we talked about this once before, but oftentimes the parties will be willing to settle. And so come prepared to settle. Like this young lady, that Miss Yale is talking about, $3,000 from $5,000, that's not bad. Now that's more than 50%, but you can also offer, right? You can say, look, I have $1,500. I've got $2,000. I've got $2,500. Have the money. And as Miss Yale, as you put it, right, she was able to pay them off in 3 months. I've not seen more than 3 months. They usually like 1 or 2 months. I've seen 3 months, but they're not going to go much further than that. But if you have the cash, that's a great way to take care of it. And a lot of folks don't really even know that, right? And then the added things that she asked for, wow, even better. Can you ask? Absolutely, you can ask. The question is, in this case, if they said yes, that means they were probably a first party. They owned that debt and they didn't sell it off to someone. Sometimes if they've sold it off, but they may still ask, because that's a great thing, right?
Yes, and if I could just follow up, the whole point is to be prepared, right? Think through what you might be able to offer. Think through what rationally the other side might come back at you at. And so these tips apply to any kind of debt negotiations. As I was telling you before, back in the day, I used to work quite a bit in the child support courts, where I represented a lot of men who owed back arrears, or sometimes I represented a lot of women, moms, who were attempting to collect. And so we got into these negotiations all the time. Same kind of thing here, whereas we're talking really now about credit cards and small claims courts, but it's the same kind of philosophy. When you go to court prepared, or you go to the mediation table prepared with a plan of action of what you may want to get out of this, you're going to come out a lot better, potentially. No guarantees like anything, because the other side might not go along with your deal, with your offer, but certainly going prepared is a lot better than just showing up and winging it.
Yeah.
All right. So next one, is this me, Natalia, or is it you?
It is you, Mac. Okay.
Okay. Thank you. So the next step out of the top five ways to negotiate debt in small claims court is know if you even have a hardship. Tye, go ahead and explain a little bit more about this.
Sure. So in essence, right, when that debt company, that credit card debt purchaser, when they sit down, they're gonna let you at mediation. They're gonna let you know how much it is that you owe. They're gonna break it down, attorney's fees, court costs, interest, the principal, and what have you. And they're gonna say, okay, it's a total of, let's say it's $5,000. And the more it is, the more they're gonna want on a monthly basis, right? And oftentimes they've got their marching orders, and they're not going to accept less than X, right? So the more it is, the more they're going to ask you to pay every month. Now, if you're there in the first place, it's because you've had some kind of issues. You don't have the money. And so the question is, what is it that makes these attorneys who are in that room, why are they willing to accept less than they would normally ask, to get? $5,000, they're probably going to say, okay, we're going to ask you to pay $250 a month. It's going to be a lot higher, right? But there are instances when they will, right, automatically, they'll start to accept another number. And one of the easiest ways is when people have hardships, right? They've experienced a hardship. And so when you're in mediation, there are key words that will make the other side easier able to go that route, right? So if you can't pay $250, well, the question is, how much can you pay, right? And why would they be willing to take less? They'd be willing to take less if, for instance, you have a hardship. I lost my job. My wife, my husband got sick. We have only one income. I support the entire family. So if you have a hardship, let them know that you have a hardship. That is one of the reasons that they are going to be willing to then make a phone call to say, okay, look, they have a hardship. This is all they can pay a month. So if, and they're going to want the most they can a month, but you have a hardship, then they'll start being able and willing to work with you. And so no, right? If you have a hardship, that's going to be one of the triggers that's going to allow them to start to allow you to make a lesser amount of money, to pay a lesser amount of money every month.
Fantastic. And can you please tell us something more about those hardships? Because when I listen to what you've said, I also believe that what you're saying appeals to people who do have hardships. It's not like trying to for people to make up conditions that don't exist, because you have to be true about what you're saying so that you're able to convince people to your conditions, to make them bend towards your needs to meet into an agreement. And tell me, how about COVID? Is COVID this sort of hardship?
That would be a great hardship.
And if yes, how? In what way?
Well, so how did it affect you? So what we normally will hear is something like, I lost my job, right? There's so many things with COVID, but right off the bat, COVID has just had such an impact in all of our societies, regardless of where you are, that I can easily see any one of a number of situations because someone got COVID, right? Or someone has COVID, or we got COVID and I lost my job, and we lost our house and we've been homeless. I mean, the thing about hardship is that it tends to compound itself, right? And there's and because something happened, you weren't able to pay some bills, and because you weren't able to pay some bills, then this happened and this happened. Let them know what that hardship is. COVID is easily one of those, but people getting sick, people getting divorced, pick any one of, I lost my job, right? I haven't been working for a while. We're going bankrupt, right? Bankruptcy is another, good one that'll stop them, right in their tracks. A lot of ways. That's a different discussion, of course. But what is your hardship? Don't forget to tell them what your hardship is. And hardship is also they say some people are uncollectible. What they mean is that even though you might get a judgment on them, because maybe they're the sole provider, right, for the family. They're the only one who's making an income, for instance. That's a good one. Or any one of a number of things, right? That's why you want to get legal advice. But that's a reason why they will, in fact, right away say, okay, we understand. Sure, we'll be willing to negotiate with you. And then you're going to be able to get a number on a monthly basis that you're going to be able to afford to pay.
Thank you for that, Tye. And tell me, we are wrapping up to our fifth way that will be helpful. And we already know the four. The fifth one would be to know your budget. Why is it so important? What sort of example can you give for that?
Well, kind of right on the tail end of what I just said. And that is, so you're negotiating. And at the end of the day, the parties are going to say, okay, we agree that you will pay X amount down, or you're going to pay this much a month, right? And you're going to pay that until such time as the entire amount that you're being sued for is paid. How much is that, right? Now, they're going to want as much as they possibly can. Don't agree to an amount that you're not going to be able to pay for, right? Because you're just setting yourself up for a judgment, in essence. Now, agreements are going to be different from state to state, from country to country. In the Ninth Circuit, in Florida, where Misael and I have mediated these kinds of cases, there's a clause in there that says, if you stop making your payments, right, then a judgment will be entered in against you for the full amount minus anything that you will have paid. So it's really important that, if you can only afford 50, 75, 100, that's what you agree to. Don't agree to 150, 200 if you're not going to be able to make it, because at the end of the day, you're going to have a judgment against you, right? So if you agree, make sure that you can afford it, right? And let them know what it is in good faith. And more often than not, if you have a hardship and if all the things are, going in your favor, you may very well be able to come to agreement, hopefully. But don't bite off more than you can chew, because it will bite you in the end.
Yes, and thank you, Tye. And Tye brought up the example of the Ninth Circuit in Florida. In Texas here, I've done a case where I negotiated on behalf of a client with a bank, for credit card debt that she had owed. And we ended up agreeing, we have something called a Rule 11 agreement, basically where parties can sign off and file it with the court. And the agreement basically said what you said, that this is the deal, that the client is going to pay these installments until the debt's paid off, or this lump sum by a certain date. But if they don't, then, you can have a lot of problems. Okay. So make sure that you actually follow through with the agreement, any agreement that you might have made.
Follow through, right?
Exactly.
Honor your agreement, as Misael says.
Exactly. And so this takes us to the end, where let's recap the 5 top ways. So number 1, get legal advice. Okay. Yeah. If you're not going to bring a lawyer, well, at least go speak to somebody so you can know your rights.
Or at the very least, research. Come prepared.
Exactly. Number 2, if you can, then bring an attorney. Probably better to have somebody on your side anyway, just in case the other side, who's not your attorney, tries to play some games.
And sometimes in debt cases, they may not charge you. Depends on the case. They'll let you know.
Yep. Number 3, be prepared to settle with some number that you have in your head. Okay.
That you have the cash for.
Yeah. At least you have come prepared and know what you may or may not do. Number 4, know if you have a hardship. And sometimes COVID-related issues might be hardships, but just be able to prove your disability, be able to show that you are completely unemployed. Okay. And finally, number 5, know your budget. Okay. Don't set yourself up to fail. Make sure that you can come up with a plan of action that's going to actually let you to be successful at the end. Okay. Whatever state you're in. All right, guys.
And Mark, wait, I see we have a couple of seconds. Let me add a little more to that, because at the end, I always tell the folks, by the way, if you want to make more than one payment, let's say you make 2 payments, great. But that doesn't mean the next month you don't have to make another payment. You absolutely have to make another payment. Remember that. One. Secondly, typically they're going to give you an address where you have to send your payment to, right? But you can also set up electronic payments, but you're probably going to have to call and follow up with them in order to do that, right? And then if you can't make a payment, call them, tell them, because if not, you might be in trouble. Thank you, Mark. And Natalia.
Yes, no problem. So, guys, we're wrapping it up now. Thank you, everyone, for showing up. Thank you, Tye and Monsieur. Good luck to you.
Yes.
And thank you for participating.
Thank you.
My pleasure. Have a good one.
Yes. All right, guys. Until next time.
Look forward to it.